Hey guys, remember to like the video and hit subscribe.
Certainly. Well, it started with the famed Iowa poll. This is a poll that's been conducted for decades on political activity in Iowa. It is conducted by our client, Ann Selzer, and Selzer and Company. And 3 days before the November 2024 election, it came out finding that Kamala Harris had a 3-point lead over Donald Trump, a surprising result, to say the least, and one that ended up not being borne out by the ultimate vote. Not a real news flash. Sometimes polls don't actually serve as predictors of how elections actually come out. Nonetheless, a couple of weeks after the poll result, um, Donald Trump filed suit against the Des Moines Register, its parent company, Gannett, and against Ann Selzer personally and her company, Selzer and Company, claiming that the incorrect poll amounted to fraud under an Iowa statute that prohibits consumer fraud, and that is lying in the sale of a product uh, to induce a charitable contribution.
Mhm.
Nothing in the statute, of course, remotely relates to this. Um, that case was filed in state court. Um, it was quickly removed by Gannett to a federal court, and that's one of the issues that we'll be confronting. And on Friday, the Trump complaint was amended, a new superseding second or First Amendment amended complaint filed in federal court that adds two Iowa politicians as additional plaintiffs in the case. It also alleges some additional claims involving uh, um, basically negligent and intentional misrepresentations under common law, in
Mhm.
addition to the statutory fraud claim. So that's where the state of play is now. The parties will begin to fight this out in federal court. We expect that the plaintiffs are going to try and get it back into state court, and that's where the state of play is right now.
Do you think as a real quick thing, is there a way you can turn your microphone volume up a tad? And then under the um, I think there were some other causes of action added to that amended complaint. And then we looked up the Iowa statute for the original complaint. Is when you move something to federal court, you can still sue over the statewide or the state level complaint, right? You're just taking it to like a federal court.
That's right. And there are a couple of reasons why under the procedures, under the civil rules of civil procedure, you would be able to remove a complaint. One is if it deals with federal issues. The other is if there's diversity between citizens of different states. Um, Here, the latest amended complaint is an effort to defeat diversity and to try and get it into state court by adding Iowa plaintiffs. And again, those are the issues that will be resolved in due course by the court.
Is there any way that under that original statute, I was trying to read it, and I understand that things can apply in ways that we don't necessarily understand, or like a layman wouldn't understand. The original complaint looked like it had to do with basically engaging in fraudulent activity to like sell a product. I think merchandise is the underlying word.
Exactly. It's the
Mhm.
kind of law that exists so that consumers can sue if a car dealer turns back the odometer before selling you a car.
Yeah.
Things like that. Those are the kinds of things. It's never been applied to fake news, which is what the effort is being done to do here, to torture this complaint into a cause of action that was never contemplated.
Hmm. I'm curious when you guys have to consider whether or not you take on a case like this, um, like because I imagine there's a whole bunch of dimensions at play here that go beyond just the legal one. You've got the PR angle of the president is suing a client that you're representing. You've got obvious implications of freedom of speech, even beyond just the legal stuff, just the idea of the president suing somebody for freedom of speech. You've got all the potential negative PR that you guys could get. Um, on the third part, because I've done work with fire sponsored stuff before, and
Yep.
maybe it's just the perspective of who I'm with. I think traditionally, as the ACLU has kind of gone, I would say more, they've gotten a lot of money from being anti Trump. I'll just say that much. And then Fire seems like they've represented a lot more kind of like pro freedom of speech, which over the past 5 years tends to be more on the right. Will you
Well, it has
work?
been coded that way, but
Yeah.
I don't think that necessarily covers the field
Hmm.
of defense of free speech. I can give you a little bit of background that speaks to that, and that is that FIRE considers itself to be, and we actively want to be, nonpartisan, nonprofit. We don't care what the political valence of it is. If speech is protected, we defend it. And that's true across the political spectrum. And that's particularly true here. And we don't see this as an anti-Trump thing. It's an anti-violation of the First Amendment thing. It happens to be that the plaintiff in this case uh, is someone who has threatened the press in the past, and this is the latest manifestation of that. But what we're really focused on is the fact that this kind of claim against the press by anybody is simply illegitimate.
Are you worried at all about the support the organization receives? That if people see you fighting against Donald Trump or against the right, that people might think that, oh, this is another organization that's just trying to represent the left or whatever? Or do you feel like you guys have built up a pretty solid, I don't want to say fan base, but like a group of people who support you that understand that freedom of speech is a left and right issue?
I think our track record speaks for itself.
Hmm.
We have been steadfastly in support of the basic principles of free speech and a culture of free expression, regardless of the political consequences one way or the other. And so, while some people on the right may take offense at this position, that's just something that goes with the job. My colleague, Will Creeley, put it really well when he said that when it comes to free speech, we're like the ambulance driver. You go and deal with what the consequences are. You don't ask the political affiliation of the person who's been injured or a plumber who goes to fix a sink. We don't care uh, what clogged up the sink,
Hmm.
uh, whether it's codes left or right. We're just there to deal with the principles of free speech.
When you're drafting your motions or when you're preparing to do litigation, I guess if it gets to that point on something like this, are you ever cognizant of or are you thinking of arguments that might potentially go all the way to the Supreme Court? Like, I'm curious if, like, is there ever a case you want to cite, or do you ever read like a Supreme Court opinion? You're like, I know that Alito, or I know that Thomas likes this, so I'm going to lean in on this, or is this like way out of? You're not even close to thinking about that kind of stuff yet. I'm just curious what the like how long term you could ever see stuff like this going, or what the yeah what it looks like in your mind, how you prepare for stuff like that.
Well, I think it's always in the back of your mind. And one of the reasons for that is when you're talking about First Amendment doctrine, you're drawing largely from, although not exclusively, from ultimately from Supreme Court cases. And so you want to make the most solid argument that you can based on that precedent. But then you also look to the circuit courts of appeals and what's binding in this circuit. But there's always going to be a sense of if this case goes further, whether or not the same arguments would have the same appeal. Clearly, when you get to that level, if you get to the Court of Appeals, you want to know who your panel is, you get to the Supreme Court, you know who the 9 justices are going to be, you will try and frame your argument to appeal to critical mass of justices that will vote in your favor. And so that's going to be part of the calculus, but right now we're focused on the immediate arguments and the immediate motions that are going to be coming up.
Hmm. Do you do you I'm sorry, somebody I just saw a really interesting question. When it comes time to when you're dealing with litigation like this and you're thinking of like countersuing or anything else, are you ever considering the fact that you have like a private citizen who's suing a company who is now also the president, who might enjoy some kind of like strange protections? I'm just realizing in the wake of like the civil protections that the president already enjoyed because of the Nixon Fitzgerald case and now the criminal ones, that if you ever feel like your hands are tied when it comes to responding to litigation from a client who happens to be the president of the United States, or a litigant who happens to be the president of the United States, or if that factors in at all, or is this just a, yeah.
Well, it's a little bit different here, where the president is the plaintiff, and he's the plaintiff in his private capacity as, at the time, a candidate for office,
Hmm.
and this in some way affected him. Of course, the fact that he won should be some indication of whether or not he suffered any damages, but that's a whole nother question. Um, but I think it's a bigger question if a plaintiff were to sue the president,
Sure.
where there, a sense of immunity. And as a matter of fact, Trump and his legal team in various contexts have argued that state courts, at least, can't exert jurisdiction over a sitting president because it would interfere with the obligations of his office,
Mhm.
that he can't be compelled to respond to discovery requests or to show up in court and things like that. And there are some pending cases right now where parties have used Trump's former arguments and some current arguments against him, arguing that the state claims that are at issue in those cases should be put on hold for the duration of the Trump presidency.
Is this a case that you're expecting, I imagine hoping to win, but expecting to win on just like a motion to dismiss, or do you foresee this as going like further or all the way to an actual trial? Or
We expect the first pleading will be a motion to dismiss, and you're always hopeful that you'll win on that.
Mhm.
And we'll see how it goes. What I can tell you is that the arguments that we have are very solid. That this kind of claim to try and create a cause of action for false news or fake news is unprecedented, and it goes back to the beginning of the country when you think of the Sedition Act and the John Adams presidency, creating basically a crime of false publications that criticize the president or other members of the government, except for the vice president, which at the time was his political opponent, Thomas Jefferson. Um, but the Sedition Act ultimately expired by its own terms. When Jefferson became president, he commuted all the sentences and repaid all of the fines that had been paid, and declared that he considered this law as unconstitutional and as palpable a violation of the First Amendment and of the Constitution as if we had all been ordered to fall down and worship a graven image. And that sentiment toward this kind of government as arbiter of truth has infused First Amendment law that has developed ever since. And so it's really part of our constitutional DNA that the government doesn't get to, and private plaintiffs don't get to, simply claim that there is a false statement standing on its own, that it can then either collect damages based on or impose as a crime.
Mhm.
Now, there are exceptions to that. There are certain exceptions to the First Amendment, but they are limited and they're narrow and they're carefully defined, such as defamation, and which is a different thing altogether, or incitement, obscenity, those kinds of things that are exceptions to the First Amendment, none of which apply here.
Does it bother you that it feels like, unless I'm missing something, it feels like you guys are the only ones so far that have had an appetite to actually challenge Trump on any of these claims? Zuckerberg and Facebook famously settled. I'm sorry, it hurts to even say this, but I think paid Trump. It was like, was it $15 million because they agreed, or I mean, he sued them for violating his First Amendment rights by banning him from Facebook. And then you had, I think NBC settled, or no, ABC News settled.
ABC.
Yeah. Does any of these do any of these things bother you, or do you understand and you're sympathetic towards it, or yeah?
Well, there are a couple of ways to answer that question. Do they bother me? Yes, they do, because I think the fact that large, well-heeled corporations are giving in to pressure is a troubling development. I think it's not healthy for our democracy. Now, there are a lot of reasons why people will settle a case. It has nothing to do with the legal merits of the case.
Sure.
And at this point, the government has a lot of tools at its disposal to make it very painful for companies to hold out against Trump. I don't know what went on in the settlement talks in those cases, so I can't speculate as to what the reasons might be. Similar thing is going on with the lawsuit involving Trump against CBS News in Texas over the editing of the 60 Minutes interview.
Oh, God. Yeah,
right?
I think they announced that they were going to settle that one as well, right?
There has been speculation in the press that they are in settlement talks. But again, you're talking about a large organization that is in the midst of a merger where the government is in position to place a lot of pressure on the parties. Again, I can only speculate, and based on news reports I've read about what might be motivating people, but none of that affects whether or not Trump has a valid claim, which he does not.
Mm-hmm.
And so in our case, we're just simply going to look at the law. We're going to look at what we think our good arguments are. We're going to make those arguments and try and get the right result from a court.
I'm curious. I'm going to make a guess just because of what FIRE is and what you guys. I'm guessing you're a pretty big pro-capitalist guy.
Well, FIRE really doesn't have a position on that.
Okay.
And again, we are institutionally, we are nonpartisan, but also we are really pride ourselves on having a lot of diverse views among our staff, from the president on down, and you'll have people come from completely across the political spectrum. The one thing that we have in common is an abiding commitment to the principles and culture of freedom of expression.
Okay. Yeah, I only ask because typically, in I guess I'll say in online circles, it's true in real life as well. Though usually free speech guys tend to be big capitalist guys. I'm a pretty big capitalist, but I mean I have my reservations. And one of my big issues are I don't like that because some of these companies have gotten so big, or because they're facing potential mergers, there is really good financial incentive, I think, to settle some of these cases. Like I'd read that. Because the same parent company that owns ABC, it either is Disney or it's the same company. And the idea that, Disney World essentially is going to be fighting a lawsuit against President Trump, whatever they could hope to win or defend against in court, their losses are going to be dwarfed just in sales of Disney World tickets.
Look, it has always been true that those in power flex their muscles. They try and use that power to get their way, and that it takes a lot of fortitude to resist, and particularly among corporations that have a lot of pressure points that can be leaned on by various government actors. But from presidents, this goes way back. I mean, FDR was one of the presidents who pioneered subjecting unfriendly journalists to tax audits during the 1960s. The Democratic National Committee, when Kennedy was president, used the FCC, used fairness doctrine complaints against right-wing radio preachers to try and bring them to heel. And then, of course, Nixon very famously threatened newspapers and also threatened television stations owned by the Washington Post because of its unfavorable Watergate coverage. So this is something that is sort of endemic to the office of president and related agencies, and something that people have had to cope with again and again. But fortunately, First Amendment law throughout this period has advanced and has strengthened so that the arguments you can make against those abuses of power are better.
Are you worried at all with the way that I'm trying to stay away from the super partisan questions, but just on the factual matter that Trump is the president and Trump arguably is going to have more control over the DOJ than what we might hope a president would have? Are you worried at all about either unfavorable rulings as a result of that or some type of legal retaliation that might be outside of this court case? Are these things you guys are considering or factoring in at all?
Yeah, there are a couple of questions to consider there, and sort of a third aspect of that too. Personally, am I worried about a society in which the president is willing to use power of office and related agencies to put pressure on people? Yes, I worry about that. That is not a healthy state of affairs. For purposes of this lawsuit or other First Amendment claims that we may be involved with, I'm not worried, because that's why we have a third branch of government. That's why we have the judiciary that is independent.
Hopefully. Sorry,
I see you smile there. But one of the great things about arguing a case in front of a judge instead of trying to appeal to a congressperson or someone who's in the executive branch is that they have lifetime appointments, federal judges anyway. They have to write down reasons for the things that they do, and to write them down in a way that holds up when you compare them to precedent and reason. And so, I do not worry that those political factors will affect either the arguments that we make or the outcome that we get. I see, as Alexander Bickel had previously written, the judiciary as the least dangerous branch because it exists as a buffer against that kind of abuse of power. Is it perfect? No, because we live in a world where we deal with human institutions. And so you do your best. But it's been often said of the American system that it was a system designed by geniuses so it could be run by idiots. We may be in the middle of a test of whether or not that's actually true. But part of the genius of the system is that you have dispersed power between different branches of government, with the judiciary being the ultimate check on those kinds of abuses.
I'm kind of curious, since the president now enjoys so many protections against types of lawsuits that could be brought against him, do you think the president should be allowed as a candidate to sue anybody over like these types of matters, especially if he wins his election? Or
It does seem a bit lopsided,
yeah,
doesn't it?
because the president could theoretically right now utilize his voice as the president to attack Seltzer. I mean, you could argue that this has already happened, but if you were to try to bring any type of cause of action against him at the very least, well, I don't even know if you could over civil stuff. You might not even be allowed to. I'm not sure. Like, yeah, I guess how does that? Do you think that they should be allowed to do that, or?
Well, there can be civil actions against a president, but often there'll be arguments for why it should be deferred.
Mm-hmm.
But that is not something we're facing in this case.
Sure. Do you for your, I guess, like personal history, have you ever been involved in a case that I guess like had this many implications to it? Like, or do you think this is like probably the largest case like this you've been involved in your life?
I was involved in a case several years ago when I was in private practice, where we were suing President Trump during his first term, based on various actions that he had taken against the press and against particular reporters. This was done on behalf of PEN America, and we had gotten to the point where, on behalf of the president, a motion to dismiss the claim had been filed, and we prevailed. And so the case was going to go forward, but then the first Trump administration ended, and so the case became moot.
Mm-hmm.
So it's not the first time I've been involved. I guess you'd say something as big, and other cases too.
Are there any other cases right now that are active or that Trump has talked about that you're looking like to the outcomes of, where you're kind of like wondering how they're going to turn out? I don't know, besides the ones I quoted earlier that have been settled out, or I don't know if there are any other ongoing. You mentioned the 60 Minutes one, but is there anything else like that alive right now?
One, and we're watching that one closely. We're also paying attention to the previous litigation that the cases that were brought across the country, alleging election interference, alleging that the Joe Biden win in 2020 was illegitimate. All of those cases were thrown out. Some of the lawyers were sanctioned for having engaged filing pleadings they knew were essentially meritless. And so, yeah, we do pay attention to that.
Have you had anybody pressure you, I guess, like personally or professionally, to where one of the claims I've heard some people say, I heard this brought up over the ABC thing, although I don't know, I feel like it was more of a money thing, but I've heard some people say that these cases should just be settled out because of just on the chance that if they go to the Supreme Court with the current composition of the court, if somebody were to lose one of these cases, it could theoretically be, or it would be catastrophic in terms of free speech implications. Anything, yeah.
I think that's nonsense.
Okay.
And I can tell you now, Ann Selzer will not settle.
Mm-hmm.
The charges, both on their facts and under the legal theory, are completely bogus. And so if we end up going that far, then that's the way it goes. As to the claims about where this current Supreme Court is, again, people tend to see things through their own political lens. And a lot of people see this Supreme Court seeing it as being a conservative majority, as being also a politicized court in the same way that the executive branch and legislators are politicized. I don't see the court that way. And particularly when it comes to First Amendment law, the court has been really, I think, a straight shooter when it comes to, it doesn't matter whether the claim is coming from the left or the right. If the First Amendment principles support the claim, then the court has been really good about upholding what I see as correct First Amendment jurisprudence.
Mm-hmm. Just kind of curious, from like a functional standpoint, how many people are working a case like this, if you're allowed to say? Is this like you and like 3 other legal people, or is this like a whole office building organization, like 100+ people?
No,
what is that? Yeah.
It's not like the movies. It's not like that.
Mm-hmm.
No, we have a core team of 4 lawyers working on the case. And we have other assistants for some sort of spot projects here and there, but it's not where you have something where you see a conference room with dozens of lawyers milling around.
Gotcha. Do you guys pursue cases like this, or do people usually reach out to you first? Or
It's a mix of things. Sometimes we'll have people contact us. We have regular submissions that way. We also sometimes, if we see something going on, we will reach out. Uh, and it's hard to characterize whether it's more one way or the other on a given case.
Mhm. When you look at like the amended complaint that was filed and these extra causes of action and the additional plaintiffs listed, does it feel to you like the other side is just trying to bully self-served friends into some type of admission or retraction or settlement, or does it feel like they genuinely want to go as far as they can on this, or they just don't care? What is your feeling on that?
I think this case is a stunt.
Hmm.
There's no conceivable legal merit here. Um, I try not to psychoanalyze what's going on in the minds of people on the other side. Who knows what they're thinking? But what I can tell you, and I've been doing First Amendment law for over 40 years, that the claims here simply have.
In cases like this, are there ever any back and forths between the two legal parties, or are you just responding to motions in court?
Yeah, lawyers will talk, sure, and
Hmm.
we've been in touch with them, and you try and maintain, as in any case, a professional relationship and to cooperate where you can on a friendly basis, and we've been able to do that in scheduling orders so far, and we hope to maintain that level of professionalism throughout the case.
Do you guys have an expected date on when your first filing goes down, or?
Yes, I believe the deadline for motions to dismiss is coming up on February 21st.
Gotcha. Okay. Hard, I guess, because there's only been one side that's filed anything so far.
Yeah, you've seen the complaint, so you know what it's about.
Yeah. Yeah, I was reading through trying to understand the merchandise argument. It seemed pretty far fetched, but a lot of them seem pretty far fetched. So,
Well,
yeah.
it's trying to take this state statute and torture it to death to create a cause of action for false news.
Hmm.
But again, that's simply so alien to our constitutional traditions and not the purpose of this Iowa statute and not contemplated by the common law concepts that they cite. So that, again, it's far-fetched, but that's the thing about this kind of abusive litigation. It's taken and undertaken not so much to achieve a legal result, but to inflict pain on the other side. And
Hmm.
this is a litigation tactic that has long been associated with Donald Trump, that he will sue the other side simply to make a point and for bullying purposes. This is not uncommon, but it's something that you simply have to respond for.
If you do any type of like anti-slap stuff, would that even apply here? And can you ever win like punitive damages for that, or does that only ever cover like attorney's fees, or how does that work? Yeah.
Most states do have anti-SLAPP laws. These are laws against, the acronym SLAPP means strategic litigation against public participation, which is the acronym, and that it's designed to basically punish people when they exercise their First Amendment rights.
Hmm.
Iowa, alas, does not have an anti-SLAPP law, and those laws create a procedural out for an early dismissal of those kinds of meritless claims. But nonetheless, these procedures for dismissing meritless claims exist, whether or not there's an anti-SLAPP law. And so that's will be relying.
Okay. Do you have anything in particular that you feel, I guess, about this case that you want to bring up, or otherwise I can ask just a couple general questions?
I think we pretty well covered what this case is about and how we're approaching it. We see the merits of it. I'm open to discuss whatever topics you'd like to cover.
Yeah, sure. I guess just on a kind of a broader general question. So I do a lot of online stuff, political news, whatever. One of the big issues that comes up a lot, and I've had a lot of personal difficulty wrestling with this, both philosophically and legally and culturally, like I don't know what the answers are. One of the big issues right now is fake news, to where you have people that are not just getting things wrong, but are very intentionally lying about things. And then you also have this world where people are engaged in, I would call this a slap lawsuit, where people are just trying to be litigious to shut people down and to make it so they can't speak. Do you view that as a problem right now, as somebody who I imagine is a big First Amendment defender? I really enjoy the First Amendment. Obviously, I love the First Amendment of the United States. I love our freedom of speech here. But the intentional lying is really rough. And I feel like it is eviscerated our media environment in so many different ways. And I don't know what the answer to that is. Do you ever think about this, or how does this affect you?
Oh yeah, all the
Mhm.
time. I mean, and these are issues that people debate endlessly, and the concept of how to deal with misinformation. The problem is, and this, as I've said, goes way back to the beginnings of the country, and that is, how do you decide what is true if you're going to do it as a matter of law? We've experimented as a nation with having the government simply declare what's true, as authoritarian governments around the world do. That didn't work. And so the way First Amendment developed through, case law development in this country is to find that the best test of truth is to get ideas accepted in the marketplace of ideas. That has become more challenging as technology has developed, as you can spread misinformation very quickly. But as we discovered during the pandemic, um, to try and decide from a governmental perspective what is misinformation and what isn't is a really tricky matter. Take for example the Wuhan lab leak theory that was widely criticized during the early days of the pandemic. Part of the claims about the Biden administration leaning on social media platforms, saying they were trying to tamp down what they saw as misinformation, and that was a prime example of it. And yet, later on, it turned out that there was a credible argument that the origin of COVID virus came from the Wuhan lab, and that you had too many instances of government trying to suppress speech by leaning on social media platforms. So dealing with misinformation is very tricky unless you know what the truth is.
Mhm.
And then the question becomes, who do you trust to determine what the truth is? And the best answer we've come up with as a nation, I think, is that you've got to let that marketplace work. And when you're aware of to combat that with what you see as better.
Okay. Yeah, I mean, that's kind of where I'm at, very regrettably, because I wish there was a better answer there because the current environment is so bad.
Well, as
Um,
I said, I mean,
mhm.
you're right. I mean, we are dealing with an imperfect system because we're dealing with humans. And, think of the internet. I mean, one of my special areas of interest is the First Amendment and new technologies. And I've seen that develop from considering broadcasting to be the new technology through cable and the internet and so on. And so each new technology has brought with it both new opportunities, but also new challenges. And the internet is one that we're still going to be dealing with in various ways over time. And I've often said that the best thing about the internet is also the worst thing about the internet. And that is, it gives every individual a voice that can speak to the world.
Yeah.
Now, that's revolutionary. It's the first time in the history of the planet that there has been a technology for communication that is that powerful. But the downside, of course, is that people say a lot of and there's a lot of misinformation out there, some unintentional, some intentional. And the question is, how do you sort through it? If you see it as a problem that the government has to address, who do you trust to do that sorting? And when you answer that question, you've also got to ask yourself the next question, and that is, would I be comfortable with that answer if my worst enemy were the person in charge of making that decision?
Hmm.
Because that may well happen, and we may well find out how that works in the coming years.
Yeah.
Uh,
Do you have an opinion on the TikTok case, I guess, and how that's gone?
We filed an amicus brief in the Supreme Court opposing the law requiring the TikTok sale. It was our view that the decision was unprecedented
Hmm.
in that we've never had a time in which the government has tried to essentially close down an entire medium of communication. We recognize that the government had made national security arguments in favor of doing so, but it was basically just talking about potential problems that might happen versus the very real consequence of closing down this media.
Did you
Uh,
agree on the Supreme Court side? Did you agree that it was like an intermediate scrutiny, content neutral evaluation, or do you think that
no,
should have been evaluated higher?
I think it should have been a strict scrutiny analysis because part of the rationale was that there is the potential this could be used to spread foreign propaganda. Now, that's not a neutral justification. And
Hmm.
the only thing that was really halfway good that came out of the Supreme Court decision is that they said, we're not going to rely on that rationale at all. We're
Yeah.
only going to data privacy rationale and treat that as neutral and therefore apply intermediate scrutiny. But what I would have preferred to see the court do is put off a decision, since at the time the case was being considered, both the Biden administration, as it was outgoing, said it wasn't going to enforce the ban, and the incoming Trump administration said that it wanted to give more time. So it would have been preferable, I think, for the court to put its decision on hold and let the political branches work out whatever they were going to work out, and then look at the constitutional landscape after that.
Mhm. I guess as a pro, I think even in the decision, I think they explicitly said that it was a very, very, very narrow ruling that like only applied
Yes.
in like this hyper
Only
specific
applied in
example.
these very limited and unique circumstances. Yeah, I've seen that before.
Sure, sure.
Bush versus Gore. But
Jesus,
and
yeah.
the problem is the case has already been cited in some other cases we're working on
Hmm.
uh, as a justification for using intermediate scrutiny. So the trick will be to keep the genie in that bottle and keep the consequences of that Supreme Court decision as limited as possible to the facts of that case.
I guess something I'm curious how you feel for that case, because in listening through the oral arguments, initially I was very sympathetic towards the plaintiffs, but then when I listened to Liz, whoever the Solicitor General is, the government provide their counter arguments.
Elizabeth Prelogar, yeah.
Yes, who did an exceptional job. Jesus,
She did.
the argument that I was very sympathetic towards by the end of that, the 2 points that she made was, one, the point that her argument for being content neutral was the exact same content could appear and she'd be fine, or the government would be fine because it wasn't necessarily focused on the content, which is an argument. Maybe that's true, maybe it's not. But the second argument was, it does feel like there's a very weird world where if TikTok or Facebook, or I'm sorry, if Twitter, X, or Facebook is doing bad things with our data and the people leading those companies are doing very bad things, those people are not beyond the criminal reach of the government. But it felt a little bit weird that ByteDance is a foreign company that has all the protections of being Chinese, so they're outside of any criminal jurisdiction or, I mean, any reasonable civil litigation jurisdiction in the United States. However, TikTok, as the arm of that company, enjoys full First Amendment rights as an American corporation, I guess. And that like 1-2 does seem very difficult to deal with, because how do you ever rein in like criminal behavior there if ByteDance can engage in that criminal behavior overseas, but TikTok enjoys all of the First Amendment and every other protection a U.S. corporation gets?
Well, it does explain why that case was particularly unique,
Mhm.
because I can't think of another instance where you've had that combination of factors. But it's also a reason why I think I would have preferred to see the court apply strict scrutiny. And if it could then find ways to see a record that justifies the action, then okay, let's take the action then. But here it went sort of a halfway route by saying, well, we're not going to rely on evidence of, whether or not propaganda is being manipulated and people whose accounts are being manipulated for propaganda purposes. We're going to look simply at the data privacy issues, the data security issues, and decide on that basis. And it seems like under strict scrutiny, you would have had myriad possible less restrictive means of achieving the same objective, of simply having a prohibition of any data collected on this platform domestically being transferred to any hostile foreign government. That would have been one way of dealing with it without having the divestiture requirement. And it would have at least still satisfied the requirements of strict scrutiny.
Mhm.
I agree with you, though, that the Solicitor